Welcome to Sovereign Citizen Legal Encounters. All right, today we have a famous sovereign citizen who just doesn't like to follow the rules. So let's watch this hearing and see how things spiral out of control, because it always does. Before we get started, today's sponsor is Aura, and I'm going to show you why I use them to protect my data and my computer. Aura is an all-in-one digital solution that gives me peace of mind online. It protects my personal information, secures my devices with antivirus and VPN, and even scrubs my data off broker sites automatically. Data brokers collect your personal details, bundle them into profiles, and sell them to marketers, scammers, and even stalkers, all without your permission. Data brokers are required legally to remove your information when you ask, but they make the process so confusing and time-consuming, most people give up. That's why I use Aura. They automatically submit removal requests to those sites and follow up to keep your data off. And one of the greatest points that I see is that they have parental control to manage your kids' screen time and get alerts about risky behavior. All of it in one app. Try Aura for free for 14 days by going to aura.com/sovereign citizen encounters or click the link in the description. Let's go.
All right, the court will call the case of the state of Michigan versus Lindsay Dineski, case number 24S00096.
Tiffany Woods for the people. Allison Muller here on behalf of Lindsay Dineski. Ms. Dineski, can you state your name, please?
Yeah, sorry, I was just trying to unmute. Lindsay Dineski.
Thank you. All right, we're here for a pretrial today, and are you in possession of all of the documents that your client has filed?
I am, Your Honor.
Okay, can we see counsel in the breakout room? All right, we're back on the record in the case of the state of Michigan versus Lindsay Dineski. You don't need to place your appearances back on. We had a brief discussion regarding all of the filings that were filed, although the defendant has an attorney in this particular case. So at this point in time, we need to make a record of what's going on in this matter, and we can go from there. Ms. Muller, it looks like your client submitted 4 different filings. First of all, the court has no requirement because we're not a email e-filing court to accept email pleadings. We did do so. Your client was advised that there is a page limit to how much we'll accept for any one hearing. So that happened, and you should be aware that that did happen as well, and that she will need to follow any filing requirements in the future. And I believe that she represented to staff that she had filed those with the prosecutor's office. Ms. Woods is indicating she did not receive them. I don't know whether they were filed with the prosecutor's office or not. Having said that, do you have a copy of the filings that your client filed with the court?
I do, Your Honor. I received those filings were sent to the court, and just now realizing they were not sent to prosecution, I have forwarded those to Ms. Woods.
Thank you.
I sent them to the other prosecutor. I apologize. Her name was Ellie, I think, because that was the one who it said she was the prosecutor for the county. So I just probably sent it to the wrong prosecutor.
So it is a he. That is the chief prosecutor, Ellie Savitt, and they probably did not get sent to the proper place because of the way you filed them.
I filed them the way I was instructed to file them. I called and asked for instructions, and I did what I was told. So I was told that the filing requirements were to email them, and that's what I did. So, and then I was notified after the fact that there was a limit. They made an exception because they didn't notify me. And then I told them I emailed the prosecutor, verified the email. And so as far as I know, the chief prosecutor got them. I just didn't know that I was supposed to send them to the other prosecutor too. I thought, notice to agents, notice to principal. So I thought if I sent them to the main prosecutor, any of the assistant prosecutors would get them. Because I didn't know which one would be on the case today.
Ms. Woods?
Yes, Judge. I mean, I'm just opening up one of the files now. I mean, I would need time to review all of this. I would not be able to. Yeah, I would need time to review all of these, Judge.
Thank you. All right. So first of all, Ms. Dineski has counsel. So whether or not she should or has the ability to file filings in the first place is something I'm still mulling over because she has counsel. So any pleading should come through her counsel. And
Yeah, they
then,
refused to file it, so,
ma'am, I didn't
oh,
say
I'm
it.
sorry. I apologize.
I'm sure she refused to file it because it was frivolous.
And then, secondly, these are not proper pleadings. They're not filed in the proper format. They're not filed with the proper spacing. They're not filed according to any of the court rules. So
They
that's
don't
the,
have to be though,
ma'am,
which I put
they do.
on there.
Ma'am, if you speak up one more time, you're gonna be held in contempt of court.
Eh?
I thought this was my hearing. I
Ma'am,
should be able to
ma'am,
speak on my
all
own
right.
behalf.
You're not. You're not able to speak on your own behalf unless you don't have counsel, and you need to stop talking. One more talking, it's gonna find you in contempt of court, and I'm gonna give you 15 days. So please stop talking. Ms. Woods is indicating that she needs time to look at those pleadings and to be able to respond. Ms. Moeller, what is your position? I haven't heard anything from you today, because she actually has.
Thank you, Your Honor. Ms. Juneski and I did, prior to the last pretrial, discuss. I didn't know exactly what she was going to be filing, but I did understand the basis of her legal argument. Her and I had a conversation where I didn't agree with the grounds for filing. It is correct that I said I would not be filing this on her behalf because I found the legal argument not to be correct. At this hearing, then Ms. Juneski did file these motions, and so I would discuss it further with my management, but I would not be proceeding with these arguments at a hearing if the court were to set it for that. I understand Ms. Juneski does want to proceed with these arguments, and I believe that she's requesting to represent herself if this court sets this for a motion hearing.
Now, Ms. Dineski, are you requesting to represent yourself?
Well, I'm asserting my right to represent myself. I'm not requesting.
Sounds like a demand to me.
All right, then if you're not requesting to represent yourself, then what's going to happen is you're going to continue to have counsel.
Well, I'm asserting my right, which is much stronger than requesting. I shouldn't have to request something that I have a right to. It just should be automatic, right?
All right.
Like the Sixth Amendment
It is not
and the
automatic.
Constitution.
It is, ma'am,
Yes.
it is not automatic. So first
The
of all,
Sixth
ma'am,
Amendment says,
stop
right?
talking.
Well, you asked me a question. I'm answering under the
No,
Sixth
I heard
Amendment.
you. No, stop talking. So look, this is the way it's going to work. I'm going to give you what your rights are. And then if you make a choice to represent yourself, you can, after I've finished giving you those rights. Do you understand that part?
I comprehend it.
Okay.
Yes, ma'am.
So, first of all, what you're charged with is police officer assaulting, resisting, obstructing. It's an attempt. It has a maximum penalty of up to 1 year in the Washtenaw County Jail. Do you understand that part?
I comprehend that that's what you're charging with. I don't understand it because it's false.
Okay. Do you understand that that is what the maximum penalty is?
I do, which is why this is unconstitutional, because I was the victim in the case and falsely
All right, I
arrested.
think what I'm going to do is refer her to make sure she's competent,
Judge Washington's not playing.
because at this point in time, if she can't understand and she wants to use a different word, then I guess what I need to do is figure out what.
Comprehend means that I know
Yeah.
what it means. Okay. Understand means that I'm understanding the court, and I am not understanding the court because I'm challenging jurisdiction. I don't need a competency evaluation. I see a psychiatrist every month because I have ADD. So if you would like me to present to you that I'm mentally fit, that's fine. But for you to say that I have to have a competency evaluation with no cause because I'm asserting my rights, that's a violation of Shearer
Right.
versus Cullen. All I'm doing is asserting my right to
Alright.
represent myself.
Referred for competency. We'll prepare an order so she can be evaluated so we can
Well,
determine.
I object to that. I object
You
to the
can object
competency
whatever you
evaluation.
want to object to, but if you don't participate, then I'll put you in custody until we get an exam done. Do you
But why?
understand?
But you have to say that there has to be a reason. There has to be a cause for it. And I have a right to know why you are forcing me to do something that I don't want to do when I thought I had a presumption of innocence. I thought I'm supposed to
Ma'am,
not
I'm
have my
referring
right.
for competency. You need to stop talking. And if you don't participate, I'm going to put you in custody. And I already placed on the record why.
Okay, and also, isn't the officer supposed to be here today to testify? And if
No,
he's not,
that is not
well,
how that works. See, you don't
I
know
thought
anything about this, and that's why you shouldn't be representing yourself. But
I
you
did. The
understand
preliminary
you
exam
can
was supposed
only
to have
comprehend it.
witnesses.
This is not a preliminary examination, ma'am.
Oh, I thought that's what that was.
If she would have listened to an attorney, she would have known this wasn't a hearing.
I was just under the impression it
The
was a
first was
preliminary.
competency, and I'm gonna schedule this for a hearing on November 20th in person, so we can have these conversations in person and see if they go any
Well, I
different.
don't have any way to get there. I live very far away from where this is
Then
now.
I think when you get picked up and you're required to come here by police, then you'll have a way to
So
get here.
why would that be necessary? All I'm asking, I'm challenging jurisdiction, which I'm allowed to do without being retaliated against. You're retaliating against me because I'm challenging the jurisdiction of the court. And
That
that's
is
a
not what's
violation
going
of my
on.
rights.
Okay, Ms. Doneski, you either need to be here, you need to participate in the competency, and you need to be here on November 20th, or you will
Well,
be
I'm going to be
arrested.
filing with the Court of Appeals on this
Go ahead,
and the
ma'am.
Court of Claims because this
Thank
is not
you.
okay.
All right. Bond is continued for now. Once you get the notice of your actual interview from the forensic department, if you don't participate, I'll issue a bench warrant.
Okay, well,
I'm
like I
done.
said, I'm going to be objecting to.
One thing I can say about Judge Washington, when she gets done with a defendant and she has nothing else to say, she will drop them off the call immediately. We'll follow up with her when she comes back. And normally with this sovereign citizen, it's always a lot of drama. Now we're going to go back into Judge Kahn's court, where we have our favorite person, Margaret, who has been having so many issues with code enforcement. So this time it's in a regular video because the hearing is not as long as the other trials that she done had. So let's check out and see where we are with this case. Let's go.
Okay, we're on the record. Let's go ahead and call the Margaret Lecomte case. I'll put my video on. We've got Mr. Altenberg who's joining for the city by Zoom video. We have Ms. Lecomte here in the courtroom. Ms. Lecomte, there's a person to your right. Who's this individual that's seated next to you?
She is a good friend and my power of attorney. She is not a lawyer, but she's someone that I'd like to request that be able to advise me if I forget some of the things that I need to say.
Okay, and then let me just be really clear that because she's not an attorney, you won't be allowed to comment during the hearings. We have to follow the rules that dictate what lawyers can do and what non-lawyers can and cannot do. I'll certainly allow you if you're finishing up comments and you want to pause for a moment and then turn to the individual and ask her if you've forgotten anything. I think that's going to be permissible. All right, so we've got Mr. Altenberg here who's present. I asked to have this hearing because I was informed by Fernanda Bittencourt, our probation officer, that there had been some challenges that Ms. Lecomte had faced surrounding compliance with the court's sentencing order, mostly in connection with the restraining order that she sought, a temporary restraining order that was put in place. And then I understand, just heard earlier today, that perhaps a permanent restraining order, the restraining order was made permanent.
Yes, Your Honor, that was made permanent last Friday.
Okay. And so the purpose of this meeting here today is to try to find out from my perspective where things stand as far as you moving towards compliance. I had given you one extension till September 3rd to comply. That was a week extension. And then you filed shortly before that September 3rd compliance date, the indication that you didn't believe you were going to be able to comply by September 3rd. And so in my most recent order, I said I was going to ask we were going to hold off on ordering compliance until the end of this hearing today. So I am going to try to set a deadline for compliance, but I want to give you a chance to tell me where things stand with respect to your ability to remove property. As I understand it, most of the property from your perspective belongs to Mr. Lau, but if you can tell me what plans you have made at this point to move that property.
Thank you, Your Honor. Let me just tell you the steps that I have taken. Most important, I engaged Good Riddance Dumpsters about a month ago to undertake removal of the trash. On August 25th, at 8 in the morning, that the owner arrived at my house per our agreement. And to begin, Mike Lau was present. He got very angry and he would not let them start and forbade them. I wasn't home. I was in civil court at 8 in the morning getting the temporary protection order, which was granted. But that forbade me or Mike from removing anything from the property during its duration. Importantly, Good Riddance Dumpsters is just awaiting my go-ahead to begin. And I have confirmed that in a text message from them this morning. I've not lived in my house since that morning.
It sounds like that protective order is against Mr. Lau.
Meanwhile, and these are some of the steps I've taken, I found food banks willing to pick up all the frozen meat and other boxes of food from the 4 freezers in the backyard. If those food banks don't want the freezers, then the hauling company will remove them. And then all of the other items from the backyard, front and side yard, and the driveway. This includes large wood piles, tires, barrels, assorted car parts and machinery, 7 bicycles, and things I can't even identify. The 5 trucks in the driveway will be removed sometime this week by code enforcement, according to a notice I received effectively today. If the third party hasn't already retrieved them for Mike first. Another is my regular yard maintenance will mow the backyard and remove the weeds as soon as the junk is cleared sufficiently for them to get their equipment into the backyard and do so. They've been maintaining the front and the side yards as usual. I've tried to seek legal help on this to make things move more quickly. And I finally got a 15-minute appointment through SPAN, but that lawyer couldn't help me with this particular case. I've tried to contact the crisis intervention team, but besides persistent efforts, I haven't been able to talk to anybody. Maybe it was a Labor Day holiday and the weekend that made it hard, but although I've left messages and gotten callbacks occasionally, I have missed them. The temporary protective order was made permanent forever on September 5th in Judge Brodsky's court. But I haven't felt safe to spend the night at my house. And since then, the 25th, have been staying with friends.
The question is, do they really have a problem, or is this a tactic to delay the cleanup at the house? If you check out my live streams in the description, I'm running a whole series on this, and you can let me know in the comments what you think about it.
I have no idea where Mike is, but I am wary of his pattern of denial and revenge seeking when thwarted or crossed. And that is why I request an extension set so that I can implement the steps I've just outlined and basically restore my property to what it was like about 3 years ago before I had the injuries and things began to fall apart because Mike simply took advantage of that and moved stuff in when I was unable even to check the backyard to see what was out there. I want assurance that I can remove Mike's property now without fear of his retaliation and without committing an act of contempt of court. And I hope the court will see fit to note that my efforts to comply have been ongoing and persistent and persistently thwarted. I am deeply committed to cleaning this up, not just because of the court order, or because I am facing jail time at all, but because I want to be able to live in my house and enjoy my yard, and I want my neighbors to stop being distressed, so that I can live there again. And therefore, I beg that I get a little time to do that, as long as it takes the hauling company to remove things. There is so much stuff there, I can't give a good estimate, but I suspect it will take at least a week to 10 days. barring discovering other unpleasant surprises.
For those of you who are just seeing this case for the first time, check out the live stream because this has been ongoing for over a year, and then you'll get the gist of the entire case.
So I guess I just I thank you, Your Honor, for listening to me and for giving me these many opportunities.
Okay. So you said you confirmed by text with Good Riddance that they were still able to do this?
Yes, I have been in contact with them and kept them informed of the court proceedings and the impediments that I had. And the Nathan, the owner, has responded very, very promptly and said, we're just waiting to see when we can start. And as I said, he actually showed up on August 25th before a lot of this transpired and was ready to begin. And that is when there was a big scene with Mike in the backyard over his efforts to at least survey what was out there and begin.
Okay. So you didn't set a date then for Good Riddance to start?
Well, as soon as I contacted Nathan yesterday, and I told him that I would let him know today what the outcome of this hearing was, and that I would let him know then exactly when he could begin. And I received confirmation from him that that's okay, we understand, just let me know.
Okay, so if you were to contact him, let's say during the day tomorrow, you could get something scheduled to get started?
Absolutely.
Okay. And then it may take...
In fact, Nathan said, contact me and we'll set up a plan.
Okay. Mr. Altenberg, I'll give you a chance to weigh in. What I'm hearing from Ms. LeCompte is a request to give her an additional extension of time. She didn't ask for any specific amount of time, but I'm considering extending the compliance date by 2 weeks from today's date, which would be the 22nd of September. I haven't made that an order of the court, but I wanted to give you a chance to hear what I'm thinking. You can weigh in, and then I can also hear from Ms. LeCompte after you've weighed in.
Yes, Your Honor. I just have a couple of questions, if I may, to ask Ms. LeCompte, if that's possible, just to get a better understanding of her plans. Is that okay, Your Honor?
Well, because I'm more comfortable with the court asking her questions than you because she hasn't taken the stand as a witness.
Understandable, Your Honor. That's
why don't
okay
you tell me what your issues are, and then I will pose those as questions. But why don't you tell me what your concerns are, and then I can try to address them with Ms. LeCompte.
Of course, Your Honor. Ms. LeCompte did notice or did mention that code enforcement is intending on removing the vehicles on the property. I just wanted to make sure whether or not that included all the vehicles, including vehicles that are parked alongside the property, what aspect code enforcement is intending on using, because I was not informed that code enforcement is intending on removing this at this time. It also sounds like Ms. LeCompte is trying to work with a plethora of different entities right now. One of which being the Good Riddance entity, another one being the food bank, another one being code enforcement, and then also mentioned that there may be underlying other items that may require even more time. I just want to know that, want to make sure that it sounds like there's so many moving parts here. I'm unsure if any amount of time is appropriate based off of Ms. LeCompte's current plan, because trying to coordinate all this at once and trying to come into compliance within the time frame, I do believe is difficult. And obviously, Your Honor, at this point, it has been to approve of a 2-week extension would give her a total of almost 2 months of time since the original hearing date on I believe it was the 6th of August to the 22nd of September. Originally, it was set for 3 weeks for compliance, Your Honor. And if you were to grant this extension again, it would come at this point almost to be around, I think, 7 weeks, almost the 2-month period. So we do have issues with that as well, because obviously, Your Honor, as we've noted before, the desire of the community is to have this come into compliance as soon as possible, and further continuances, despite there being an aspect or at least a declaration that there is a plan ongoing, we are worried about the possibility of maybe a further continuance being requested in a week and a half time and then having this hearing once more.
Okay. So I have all of that. So, and I'll just allow you, Ms. LeCompte, to respond to, first of all, to my thought, which that I'm inclined to grant 2 additional weeks to come into compliance, but also to the, if you respond, if you choose to the comments that were made by Mr. Altenberg. So go ahead.
With regard to the 2 weeks, Your Honor, I personally think that would be sufficient if Good Riddance it has enough time and the equipment to do that. Having not developed a plan with them, I can't really say, although I think it's a sufficiently large company that they can handle it. But again, I just don't have the information about that. The second issue, and this is regard to some of the things Mr. Altenberg said, I am not working with multiple entities. My primary entity is the hauling company, and the others have been, I would prefer not to throw away a lot of frozen meat if somebody can, if a food bank can take it. So that happens to be an ancillary desire to do some good. And if that is not acceptable, I will simply tell Good Riddance, who has already agreed to take away the freezers in which those food items are, and dispose of them. Secondly, the other, I don't remember any other entities that Mr. Altenberg mentioned, other than possibly the food bank and my mention of desire of the 7 bicycles. But basically, the person's going to handle everything is Good Riddance. So there isn't anybody else involved.
Now, during her trials, she never mentioned that it was food in any of the refrigerated items that were outside. Now that someone's on their way to pick them up, she needs to figure out if she can get the food donated so it won't be thrown out. Within a year or so, this has never come up in her other hearings.
As to the delays, those were primarily caused not through my efforts, but through my partner, who was making my life miserable and threatening me if I touched anything of his items. And that is why I sought the protective order, because I became afraid. And he is now permanently barred from my property and from any association with me. And he is gone, so that barrier is gone. And I am fully prepared to start tonight to inform Good Riddance that they may begin as soon as they have a cleared schedule to do that. I have no belief that they don't have a space for me, and I would like to have a plan to proceed before I can tell the court exactly how long they estimate it would take.
Okay. All right. I will point out for the record that Ms. LeCompte, since my last day in court with her, has been in good communication with our probation officer, explaining to her on a fairly regular basis what was transpiring between her and Mr. Lau. And she has taken steps to come into compliance. And although the case that we had previously and then this case have both dragged on for a long period of time, I do believe that the major impediment to success for Ms. LeCompte is now removed. And so I'm going to give you 2 weeks from today's date to come into compliance.
Thank you, Your Honor.
In addition, what I will expect for you to do, Ms. LeCompte, is by Wednesday at 4 p.m. of this week, I want you to notify Ms. Bittencourt, our probation officer, by email of the information that you have from Good Riddance as to the start date and when they can the start and finish date of removing everything from your premises. How you accomplish getting everything off the premises is up to you. So if you choose to try to navigate so that you can give away the meat and then get the other objects that are storing the meat off the property, I'll leave that to you. But you have to understand that that can't be something that stops you. So if you can't get someone to come over in the next several days and in a way that it works for good riddance so that they can remove those freezers, then you're going to have good riddance take the meat and do with it what they need to do. Because it's more important at this point for you to come into compliance than it is for you to do this other good thing, which is right. Wasting good meat is a terrible thing to have to do, but you're choosing between two evils at this point, as opposed to trying to make the world work and all things work at the same time. Make sure that you come into compliance. And if good riddance, you call them tonight and they say, sorry, we can't start until 10 days from now, you better find another company. That's what you need to do, is find a company that can do it and can get it done in the next 2 weeks.
I understand that fully, Your Honor, and I'm prepared to do that.
Okay. I believe you are. So I believed when you left the last hearing that perhaps the light bulb that was going on and had gone on, that you cannot control Mr. Lau and you're going to need to do this on your own and not have his help in doing it. And I think that's why you now have a restraining orders, because you took those steps. Despite what his intentions might have been, you took those steps and that put you at odds with him. And unfortunately, your longstanding relationship is now one that's subject to a restraining order and a domestic violence incident that I was not party to. But it concerns me that you're in this situation. I do believe you're in a position now where you can move forward. So I want you to take every step that you possibly can to make sure that you are in compliance. We won't have a hearing that date. That will be the date that someone from the code enforcement goes by the property to determine if you are in compliance. And then they will notify the prosecution and our probation officer. And then if you are in compliance, there won't be any action that I take. If you are not in compliance, then there'll be a show cause order that will be issued and you'll have to come and explain why you're not in compliance. And I think I told you before, it won't be, all right, the 22nd of September comes along, we issue the show cause order, and then I'm looking at what happened on September 29th or 30th, or it won't be what happens after that. It's going to be what happens between now and that date. Does that make sense to you?
I fully understand that, Your Honor.
Okay.
Can you simply tell me the 2 weeks from
today?
What date is that?
It's September 22nd at 4 p.m. You need to be in compliance. And I'll do a short order to that effect, extending the deadline for compliance. So you'll get emailed that order.
Please do send me email if you don't mind.
Yeah, you'll get that.
Okay.
Anything else?
No, Your Honor, and I thank you very much.
You're welcome. I'm glad you have some support around you, and sorry that it's turned out this way for you.
Thank you.
All right. Take care. That'll be the end of the meeting.
Thank you.
Thank you both. Thank you for appearing, Mr. Altenberg. We'll go off the record.
Of course, Your Honor, out of curiosity, would you like us to reach out to code enforcement at this time? Because it is my understanding they've been reaching out, or they've been notifying us, about possible, worries about the situation. We just want to make sure that we're on the same page with them, so they're not coming to us going, "Hey, we have another citation during this time frame."
Yeah, well, I'll be doing that order when I leave the bench here today.
Okay.
I have a meeting that starts. It's already started, but before the end of the day, you'll get an order, and then you can share that with code enforcement. And I would just encourage you to tell them, hey, notify us and notify probation of whatever you observe on the 22nd.
Excuse me, Your
Thank you.
Honor. May I just simply say that there are no trucks parked outside there are 5 trucks in my driveway, but there are no trucks parked around my property. Yeah.
Okay, thank you.
They're all in my driveway.
Okay.
Okay, thank you so much.
Thank you. You all
Thank you.
take care. Thank you,
Okay.
Mr. Altenberg. And we will go off the record.
Hopefully when that day passes, she'll be in compliance and she won't have to come back to court. But if she's not in compliance, we're going to be watching the next hearing. I hope you enjoyed both videos. If so, give it a thumbs up and I'll see you around on the next one.